right now. So dealing with the Silicon Valley and the bailout that's taken place here, James, they used the phrase systemic risk, and the decision was made by the FDIC and the Federal Reserve collectively. These are 2 members out of the 10 members that exist on FSOC, the Financial Stability Oversight Council. When I hear systemic risk and I see these things happening, Barney Frank came out and said there was no insolvency at Signature Bank.
Yes, he did. The father of the co-parent, Dodd-Frank, Wall Street Reform and Customer Protection Act was the full name. An expert on banking and the laws that apply to banking and the reserve levels that are safe for banking. You would think Barney Frank would be in that group of people. So who knows? I mean, it is possible that it was not insolvent. And it is possible that what Barney said is true. Because, as I have said, regardless of your political views, Barney Frank had a reputation for being very candid, even when he was in Congress. And he would give answers that were direct. Maybe you didn't want to hear it, but he often wasn't giving the party line. He was telling the honest to God truth about stuff. He obviously had a clear ideology, but so when he says it, I think it's possible that, and what he said was that the banking regulators shut down Signature because they wanted to send a message to people to get away from crypto. Closing of Signature Bank, in Barney's words, was to make them a poster child, an example for other banks not to bank crypto clients. So that's a little scary because that's not in the mandate of any banking regulator. Something like that, to make a statement by shutting down a bank with a bunch of employees and dollars of deposits and a significant component of the economic scene in New York City. So we need to figure out whether that's true. Because if that's true, then somebody has really gone beyond what they're permitted to do under the law.
And doesn't it speak to like the systemic risk phrase that's been used here? Because, what I start asking myself is that, well, did we just see this particular group of banks become nationalized through the puppet masters of a prudential regulator? I mean, am I seeing something wrong, James?
Well, technically, Signature Bank is not in the group of banks that fit in the category of systemically important banks. They call them SIBs, systemically important banks. Signature Bank is not one. So to cite that, they had to cite something to have the authority to do what they did in closing the bank and giving the FDIC the leeway to make good on uninsured deposits. That's in the law. The systemically important thing is a buzz phrase in the law that grants this authority to the federal regulators to bail out the uninsured depositors. So when you and I think about systemically important, it's kind of in the context of, wow, is this impacting significantly the entire economy? And so Signature Bank alone probably would not qualify, maybe as the third in a row, which if they had not guaranteed the uninsured deposits, then yesterday we would have seen real serious runs on a bunch
Yeah.
of other banks.
Oh, there would have been horrible, horrible hurt delivered in a cascading effect. I absolutely agree with that. Now, the funny thing of this, before we move on to our next point, we want to talk about the SEC versus Ripple case, and you've been digging down through it. So, but before we get there, I do want to highlight Caitlin Long had Custodia Bank, James. What say you, man? She had the bank that solves this problem, and they made her wait 18 months and told her no anyway.
The treatment of Caitlin Long and Custodia Bank, outrageous. Her proposal was to eliminate fractional reserve banking, lending, and hold 100% assets against deposits. It makes for an indestructible bank that would be the easiest bank to regulate in the world. You wouldn't have to examine, wow, are these bad debts or, whatever, or in a disfavored industry, or did they take improper duration risk and things of that nature. This is the safest banking model I've ever heard of in my lifetime. And a lot of people believe that our banking regulators and the SEC are protecting the incumbent big boys. And that Custodia Bank was a very, very attractive alternative, not just for crypto, but for a lot of people that are simply looking for a reliable means to trade in and out of fiat currency. And that's what she was going. Hopefully she will do. I think she's got a very good chance in her case to show that what was being done, what has been done, arbitrary and capricious. I'm optimistic and I'm happy because she's a fighter. So you've got a fighter in John Deaton on that XRP case, and Caitlin is inherently a fighter. And when the adverse decision came out that she's appealing, I said I would tell you not to quit, but I already know there's no chance you would quit. So it would be great for the entire digital asset ecosystem, for there to be multiple banks on the model of Custodia Bank.
Yeah, I completely agree. And shout out to Caitlin Long. She is a fighter. She's not giving up by a long shot. You can see that. She actually said she's going to be bringing some evidence that shows her case a little even clear, I guess a little more clear than it already has been. But I do hope that she gets it straightened out and has an opportunity to pursue Custodia Bank, because I do believe, from a macro perspective here, I do start wondering if at some point we're going to switch from, a debt-based system to an asset-backed system. What would be a better place to start? At some point, there has to be a rubber meets the road moment. I mean, it will be very telling to see how the prudential regulation over these systemic risk banks now, right, are handled and what is required going forward. I think that's going to be very telling to watch that very closely on that. But go ahead.
I agree with that. And I went for a run this morning and I was thinking, who are the winners and the losers from the last few days? Obviously Bitcoin and a lot of the other cryptos have performed incredibly well. And so there are winners there for sure. But I feel like the Fed has lost a little bit of credibility because as people started looking at the balance sheet of SVB, it was obvious that they had a problem with their net capital ratio if they ever had to sell their long duration assets, because the valuations were way down as a result of Fed action in raising short-term interest rates. Value of long duration treasury bonds go down. Now, if you can hold those to maturity, then you're okay. But if people start coming to your bank and in unexpectedly large numbers saying, you know what, I want my money, then you got to start selling that stuff. And then it is revealed to the world that you've got embedded losses there. And there was nothing tricky about this. It was sitting there in plain sight for the Fed and the California banking regulator to see. And we need to understand why they looked the other way when it was so obvious. I mean, as I looked at reports on this yesterday, there are some banks in a similar spot where they're weighted too heavily to long duration assets, not just U.S. bonds, but as well as mortgage-backed securities. Silicon Valley Bank stuck out like a sore thumb as the worst managed bank, certainly in the United States, and it could be the worst on the planet in terms of how out of whack their asset base got. And how the regulators let this go is really puzzling. But in any event, your winners and losers, I think this helps Caitlin a lot.
Yeah.
You know, it's tough for the Fed to say, you know what, we know what's best. We looked over SVB and Signature Bank and whatever. See, we know what, wait, I guess you don't know what you're doing. And this business model that Caitlin's got makes a lot more sense than anything you're saying.
Isn't it really is to me. I do believe it, you know, look, it was a long weekend for everybody, you know, I mean, there's no doubt. And I'm sure that there's still a long weeks ahead for a lot of people yet. But for Caitlin, I do believe she had some wind put in her sails, and rightfully
Right.
so. I do want to see her bring it in for a landing. Now, let's talk about the SEC versus Ripple case, James. I mean, you looked over the expert Dalbert motions, I believe. Is that correct?
Correct. Yes.
Okay. So I mean, what's your thoughts here? Like, how do you see this shaking out? What did the tea leaves saying to James? Are we going to Supreme Court? Is it a settlement? What are we doing here?
Well, you know, it's clients always want to know, like, this just happened. What does it mean for the entire case?
Yes.
And that makes lawyers a little nervous and reluctant to say something that the client really latches onto, you know, as, hey, maybe, you know, this means this. But for me, I believe that the net of all of those rulings was good for Ripple. And I try to explain that in a tweet thread. I look at everything that happens in a case from the lens of how is this going to land with a jury? And so in the Southern District of New York, civil case, you get a jury, unless it's waived by one of the parties, you get a jury of 8 people. And my guess is in that jury, you will have a maximum of 2 people. Now, the other 6 are going to be people in, you know, any other walk of life who don't own any crypto. None of their kids own crypto. They don't know. All they know maybe is Warren Buffett and Charlie Munger think it's terrible. You know, that's literally what you're dealing with. And so when I saw the rulings that Ripple would be permitted to have their expert testify that the IRS has already determined it ain't a security, XRP, it's property, and that under generally accepted accounting principles, which govern every public company and private companies, you know, follow GAAP as well. They say you should not treat XRP, I think is what, not a generalized statement, XRP specifically, as a security on your balance sheet. So it's supposed to be counted as an intangible asset, not a security. And then thirdly, an expert is going to be able to tell chapter and verse of the utility of XRP and the XRP ledger around the world, where it's not, clearly not, being used as a security. So when I think about those three things, I think the jurors are looking for something they can latch on to that makes sense to them. And if parts of the government and the administrative agencies that pass on changes to GAAP and the rest of the world have all concluded that it's not a security, that will resonate with them. The rest of the case has quite a bit of complications. There's a lot of complicated expert testimony about how and whether the price of XRP reacts to developments at Ripple. You know, is there a correlation? Is there causation? Because that feeds into, as you know really well, it feeds into the Howey test. Well, I'll tell you what, that's really, really complicated. And you're going to have two sets of experts saying the other side's wrong. They sort of net out. And you're left with, in my opinion, some really strong, simple statements. IRS says it's not a security. GAAP says it's not a security. The rest of the world says it's not a security. If I'm, if I know nothing, that is something that would be big in citing it in the jury room.
It is exciting to know that we could be expecting a ruling at any time, because it does feel like, I know from what John Deaton has said and other legal analysts in the space, when they release something like this, it almost felt like to me, and I'm just observing, you obviously you would know better than myself, but it felt like to me like, hey, I'm going to rule on this stuff and I'm going to let it sit for a few weeks. If you guys can't figure this out, I'm going to come out and rule the rest of it. But I think both parties kind of get a feel from the Daubert motions about where my vision is to make a ruling. Is that accurate?
Yes, that is accurate. A couple of things. So number one, that it was quite detailed in the sense of analyzing how the expert testimony fed in claims of the SEC and defenses of Ripple. And so what I believe is the judge has really done most of the work, maybe all of the work, to analyze the strengths of those claims given the evidence that has been submitted and the expert evidence that she's going to submit. So yeah, I am in the camp of seeing a ruling soon. What soon means, we'll see. But it feels like a lot of the work has been done. Your other point, though, is something that is pretty common with federal judges, where they will say something from the bench or even put things in a ruling to signal where they are leaning, to signal to the party who maybe didn't get the best of it that they should think about settling the case before the full ruling comes down. That definitely happens. It's happened in my career. So we'll see, get better information, certainly from the people like John Deaton, who are closer to the case, about whether there is any, grounds that they could meet on in the middle. It's pretty tough for the SEC to agree that that XRP traded now is not a security, would be giving up a lot, because then that would be cited, as everybody knows, by tons of other projects saying, us too, exactly.
I think so too. Yeah, I agree with you. And it's going to be very interesting to see what that ruling says. There's no question. Obviously, we've all waited a long time, right? But I mean, I believe it to be a virtual currency, as FinCEN has said years ago. Again, right. To your point, the IRS, I think these are all crucial points to really stand on for the judge's ruling going forward. Now, out of this case, there's a lot of different areas, as you mentioned, in here to rule on. The last time you and I had talked, I explained that I thought maybe this thing goes on to the Supreme Court, but I didn't necessarily think that it was bad for Ripple. I see a positive outcome for Ripple, and the SEC being the party that's appealing somewhere along the line. Anything? What are your thoughts on that idea?
I think if the SEC loses something substantial, they will appeal. And I think the same is true of Ripple. So the appeal, let me step back. If there's no complete and total win for either party on summary judgment, if some of the case remains, then it's going to go to trial. And that's going to take some time because you don't typically get to appeal a part of a case being dismissed until the whole thing has been resolved and there is a final judgment by the trial court. So you got to wait. If some part of the case is left, and I think that is likely that some part of the case will be left, then that means, Brad, people are going to have to continue to be quite patient. There'll be a trial and then a decision of that court. And then it gets appealed to the Second Circuit Court of Appeals. That takes in the range of a little under a year. And then at that point, whoever loses can file a writ of certiorari. There's no right to an appeal at the Supreme Court. You have to be granted a writ to appeal to the U.S. Supreme Court. Now, this case is so important that I think there's virtually no chance that the writ would be denied. And so it would go up to the Supreme Court, and you can count on about, and then if there is a ruling by the Supreme Court, it really will, for all intents and purposes, displace the Howey test when it anything in the digital asset world, anything having to do with blockchain or whatever, it will be the Ripple test going forward. Now, there's one other thing to consider here in terms of timing. And that is, and I don't see that many people talking about this, but there is a possibility of a change in administrations in January of 2025. In this case, it could be pending at the Second Circuit Court of Appeals, for instance. And people need to understand it's not that unusual for the government to change its position in litigation when a new administration takes effect, particularly if they are not ideologically aligned. So if another Democrat or if President Biden is reelected, nothing's going to change. But if somebody else, a Republican with a different point of view on digital assets comes in, then there's a possibility of somebody like Brian Brooks or somebody who is a real expert in the area coming in as the chairman of the SEC and saying, this is no longer our position. Ripple's not a security. And so the case could be dismissed or settled at that point when the government changes their position. And I think that is something to consider, and that could happen, in early 2025.
So ultimately, if it goes to trial, if it goes the distance, let's say, what are we talking, 3 years?
Yes,
easily,
I would say about
3 years?
3 years, yes.
But that doesn't necessarily mean that we're not informed along the way about a partial ruling that would allow, let's say, Ripple and XRP to begin U.S. adoption and start those things. And that could happen, just like it could be cited for the SEC, and it's 3 years of them continuing world adoption outside of the U.S. the way they've been doing. Correct?
Right. That's right. And I think you and I talked about it last time. What happens if Ripple wins round one? at the trial court, or wins to a degree that there's a determination that XRP trading now is not a security, then it's on to Coinbase and Gemini and the rest of them. Are you going to relist XRP, or are you going to wait for the Second Circuit Court of Appeals? Well, if you think about it, Ripple would be unique. It would be the only token that's got a declaration from a federal judge that it is not a security. So in my mind, it gets hard to not list it, because none of the other tokens you have on your platform at fill in the blank exchange have that seal of approval of a federal judge. I think it tips things dramatically, even though the SEC would come out immediately, say, we disagree, we're going to appeal, judge got it wrong, here's why, whatever. The fact remains that an unnamed exchange may be listing 200, 300 tokens. One of them has the judicial determination it's not a security. One of them that's not listed has this judicial determination. So there's a really, really good argument that it should be relisted exchanges.
I think it's a great point. And then you start asking yourself, well, where would all the money go when people were in a space like this, and you have one asset that potentially gets that clarity? I know where I'm going to put my money. It's safest in the token that just was legally cleared, right? I mean, there's going to be a massive shift. Now, listen, honestly, I think we're trying to look at both sides too. This thing could go to distance. It could go in favor of the SEC, and there's 3 more years of global adoption and no U.S. adoption. So I just want to, level a playing field out there.
Yeah, that's right. And the people that I've talked to, I've said, I think that this trial court is the toughest hurdle, actually, for Ripple. I think the chances of prevailing go up at the Second Circuit, regardless of what happens at trial. And because the Second Circuit is very, very focused on not being overturned by the United States Supreme Court. The United States Supreme Court in the last few months has made it really clear they do not like federal agencies overstepping the bounds, overstepping the mandate that they have that is rooted in statutes passed by Congress. When they see some agency sort of making up an interpretation that goes way beyond anything that has been accepted in the past, the Supreme Court has said, you need the authority of Congress to do that. And I think the Ripple case fits really well, and others have said this, so I'm not the only one. The Ripple case fits really well in how the Supreme Court is talking about agency overreach. And the facts you have are quite good, with the Hinman speech and, not doing anything for years and years and years, suddenly saying, in retrospect, years ago, that was a securities offering and they're still securities. That, gets into what is due process and fair notice. And so there was a decision within the last week or two where Justice Gorsuch was joined by the newest justice, Johnny Brown, talking about the importance of fair notice. And as I tweeted out, people need to understand fair notice is no technicality. Fair notice is a underpinning of the concept of due process, which goes in years to the Magna Carta. It used to be the king could do whatever he wanted to his subjects and fine them or imprison them and say, you know what you just did there is illegal. It is. There's no law. How was I to know? And the people at that time got tired of it. It forced the king to sign the Magna Carta, which acknowledged that they would be governed by the rule of law and that inhabitants, citizens, had the right to be informed in advance what is prohibited so that they could decide, am I going to follow the law or am I going to intentionally violate the law? And that is a 1,000-year-old concept that has come through the English common law to this country. And to make it up later is just really offensive to our notions of this whole country of what due process is. And I know I'm getting on a high horse here a little bit, but Brad, but you look at the Ethereum case that was filed in federal court in San Diego. Now there's one in New York as well. The SEC literally filed a formal pleading in federal court saying they had not yet decided whether Ethereum is a security. This is shocking. Ethereum's been around for 8 years. One of their top guys, the director of the division of corporate finance, said it's not a security. You know, thousands of projects have been built on that blockchain, and they say we haven't made up our mind yet. Well, that's not how the rule of law works. You know, you don't tell someone what the rule of law is by suing them for violating that law. You tell them in advance. So sorry for the long answer, but as a lawyer, the approach of the SEC here is offensive.
Well, look, we need to hear it, you know, and I have fought with others for a long time to expose ETHgate and the free pass that came from it. But I must say it is a little awkward, but rightfully so, to take the position now that the was it the Attorney General from New York, I believe, is now saying that Ethereum is a security as well. That, you know, it's like, look, all I ever wanted to see was a level playing field. And I know that the crypto space and certainly Ripple XRP did not get that. And Ethereum certainly got advantage and favor in my eyes. And it's obvious that, you know, Ethereum, as you mentioned, was allowed to go on and become an assembly line, a token factory, right? And it just made billions and billions of dollars without any kind of, you know, reproach or regulatory issue or what have you. And to me, that's the problem I had with it. But now that we're at a place where they may be sued or they're being sued, I feel like, okay, do they deserve a fine? Do they deserve to be sued? Sure, absolutely, because something went very wrong there, and I understand that, but that doesn't mean that I believe that the network is a security itself, right? You know, it just it was allowed to run when everybody else was told to hold, you know, to hold back, and that's the problem and the issue. And now I find myself in a place where I want to fight against the regulator for Ethereum. Even though I did all of us put this effort into exposing it, you know, it's still at this point the real problem on the field is the regulator itself.
Well, Brad, I saw your tweets about this, and I think it said a lot about you and your character, because when John Deaton, you know, planted the flag out there saying, "Look, we got to get the band back together here and fight this attempt to make Ethereum a security," there's a lot of pushback from the XRP community, understandably. And you expressed it really, really well, that when the SEC came for Ripple and XRP, that community needed support from the greater crypto world. And we needed a helping hand, support. We needed a lifeboat. And instead, we were thrown an anchor. I thought that was a great line. And you said, but even though I know that, and that did happen, I've got to leave that behind, because we've got to stop this agency overreach, whoever, you know, they're going after, even though we didn't get the reciprocal help back in the day. I thought that showed a lot of your own character, and people follow you in this community. And I think that was a meaningful contribution to the discussion, because for a lot of reasons, one of which is this thing in New York could be on a very fast track.
Yeah.
What happened there is very, very suspicious. So they used one of their investigators. Is it all right if I talk about that
Absolutely.
case?
Absolutely.
So what happened was the New York AG tapped one of their internal investigators who works in that office, and they were told, go open an account on KuCoin and see if a New York resident can open an account trade, because that would be violative of New York law. Sure, because you have to have a bit license to engage with New York residents. So I don't know how he managed to do it, he, the investigator, but he did. And so he opened an account on KuCoin, which I think is headquartered in the Seychelles Island. Here's the interesting part, Brad. There are 700 tokens listed on the KuCoin exchange. This investigator was told to buy Ethereum, and as well as the Do Kwon Terra Luna.
Yeah.
But Ethereum. Wonder why that was. There's 700 of these. He was told, go buy Ethereum, buy it, sell it, so you can say, I've traded it, I'm a New York resident, and then we'll file a lawsuit. And then here's the other tricky part, Brad, is KuCoin did not respond to a subpoena issued prior to the case being filed. And my guess, total guess, I haven't seen anything from KuCoin about this case. Not on their Twitter account. I haven't seen it. They didn't respond to the subpoena. So what does that mean? Well, it means that the New York Attorney General strongly suspects that KuCoin's not going to defend the case at all. Wow. And that the AG can go to a court in New York and say, we want an injunction, giving us everything that we've asked for, and a declaration that Ethereum is a security. And that can happen quite fast, way, way before there's any trial in Ripple. And I believe there's a possibility, I have no evidence, this isn't a rumor, this is James Murphy's speculation, that the SEC was embarrassed with what was happening in the San Diego federal court case, where they had to say, we haven't decided, or else Fred Rispoli has then a legitimate case that's going to go forward if the SEC says security. So they were stuck and had to say, we haven't made up our mind, therefore let's dismiss this case. Meanwhile, at about this same time, the AG starts this investigation, tells the investigator, go buy Ethereum so that we'll have a premise for a lawsuit against a defendant who may not even show up to defend, and we can get a declaration that it is a security. Well, this makes John Deaton's effort in signing up Ethereum holders extremely important, because he could be the only one there if he intervenes on behalf of, last I heard he said he had 1,000, who had signed up. There may not be any KuCoin, and it might just be John Deaton, which, I see this stuff happening and I think to myself, does John Deaton literally have to do everything, for this crypto community? I mean, thank God he's a Marine through and through and will take on any fight. I don't know how he has the time, but, kudos to him. I'm going to do personally everything I can to support him. But I'll tell you what, that New York AG case is extremely suspicious.
Well, I appreciate you shedding light on it, and it does feel suspicious. And when you talk about think about the idea of Ethereum, everyone's saying it's decentralized, regardless of understanding that JP Morgan's got a huge hand in this in the backside of it. who shows up? Like, to your point, outside of John Deaton, I mean, is it Consensus? Is it Joe Lubin? Like, who is actually going to show up? Is it people from the Ethereum Foundation that are going to show up? Because if they do, now they're representing it, and that even makes more to the point that it's actually a security because you're there. So it's,
Well, Brad, that's a fantastic point. Certainly occurred to me. You would think that Vitalik and Lubin and the foundation understand what's going on. I mean, their entire lives will be changed if the United States, if New York says it's a security.
yeah.
So you would think their inclination would be to run into court immediately and to stop it and intervene in the case. But you make a great point. You really are thinking things through like a lawyer. There's this risk of appearances of, see, it is centralized. These are the guys who run the show. You know, it's a security. They're promoting, you know, whatever. It's a two-edged sword and a tough decision. But ultimately, I cannot see how you don't take some action when the implications are huge for them and for every single project built on the Ethereum network, on the blockchain. So that will be fascinating to see.
It is quite a thought to think that only John Deaton would be the one in there representing Ethereum holders, and the idea that it's not a security that day. It did hit me like quite hard. I did, and I appreciate you acknowledging it, saying it. It did hit me quite hard, realizing I needed to turn around and immediately pivot and understand this is about stifling innovation. This is about, you know, we've got what we want, and it's okay if they get sued. It's okay if they get a fine, but we don't need them to be a security if it's not a security. We just need everybody to have the same shot from the get-go, which they didn't do. And if we can get past and beyond that point, we're back in this thing fighting for innovation and not just a project. And that's what matters to me right there.
Yeah, you're spot on, Brad. Again, this is a part of the government overreach. And if I'm right and there's coordination between the SEC and the New York Attorney General to bring this case because they can't say it in another case, that's quite offensive. And, you know, what's weird is there is a regulator in New York who has the responsibility to regulate exchanges that trade digital assets. It's called the New York Department of Financial Services. The New York Department of Financial Services has handed out bit licenses to Gemini, Coinbase, Paxos, and not only that, PayPal, and you can buy and sell Ethereum all day long, 24/7, in New Yorkers, because the agency that's charged with this responsibility has determined that it's not a security, or else they wouldn't have allowed them to list it on their exchange. It's a, as you know, incredibly rigorous process to get that bit license and get, you know, your listings through. And so they determined it's not a security. So now the New York AG is going off, you know, contrary to what the experts in that government have said. And it's not supposed to work this way. I'm a broken record on this, but, you know, what everyone was told in advance by the state of New York is Ethereum is not a security. It's fine to trade. And now the New York AG is disagreeing and wanting to declare security, and maybe at the behest of the SEC.
Well, let's go ahead and put a bow on this thing, because Bitcoin now, there's a lawsuit with Bitcoin, and inside of this lawsuit, because I think it's actually about something else, but within the lawsuit, they're claiming that the miners are an investment contract between the people that are participating in the Bitcoin network and the mining being done. Talk about that for a second here. I mean, this is, go ahead. We'll get there.
Yeah, this is new for the SEC, and it looks like a well-coordinated strategy to choke off, people are calling it choke point number 2, cut off the banks, go after staking, go after stable coins, all of these things, NFTs and the rest, look like a concerted effort to, I've been saying to kill it off, to asphyxiate the economy, but really it's push it overseas. Mining would certainly be something that would be quite impactful. It is a case that involves a lot of issues, but they do say the mining hardware and mining software in the form of nodes are investment contracts and therefore securities. What else in that case? But you wonder if they picked that case as a vehicle to get a judge, and then against all proof of work tokens, and we know which is the biggest one, and this is pretty profound because a lot of the public companies that are engaged in mining also do hosted mining, where a third party can have their machines placed in the data center alongside the mines owned by the public company, and they take care of everything, providing the electricity, making sure it's running the right. Mining is a pretty big business. So the idea that they're now going after that is a little bit frightening, I would say.
It is, and looking at the macro of that, because I do believe you had said it, they're coming after everything. And what I see them doing is picking like the biggest project for each type of technology. So you have proof of work now being cited through the miners and the Bitcoin miners and the equipment. And then you have proof of stake now with the Ethereum network, right? And then we already know that we have XRP being pursued, and that's Federated Byzantine Agreement. This is all these different forms of technology. And if there's something else out here that arises or is already out here that is different, I'd look for that to be sued too. All of it thrown up against the Howie. And however it comes out is legally on the other side, you find out what bucket you fall into to the regulatory side of things. That's what I see them doing here. And it quite possibly, because Ripple and XRP are first through this process, we get the Ripple test from it, which helps define everything else as it moves through it. What are your thoughts?
I think that this Ripple case is going to be one of the most important cases in the last 25 years.
Yeah.
And you really need to win, because if this is okay, the SEC is vindicated in the original issuance of XRP and subsequent trading of XRP is securities trading. Then there's really no logical end to it. I get DMs, of people saying, well, I guess this means because I bought this hoping that it would go up, and somebody's working on it, that's a security, and so it would validate a level of government overreach that is pretty close to unprecedented in my opinion. And what needs to happen is a reining in, that we should be a country that is governed by laws that have been passed by our elected representatives and signed by the president. Because I feel better. I don't know about you. I feel better if the Congress passed something, I didn't agree with it, and the president signed it. Well, you know what? I lost on that issue. And people say elections have consequences. It's absolutely right. Something's passed, I don't like it, gets signed by the president. Well, you know what? It went through the process. But for an unelected agency that's not really accountable for anything to start making decisions about, you know what, we've just discovered this is illegal and you did this many years ago, there's no end to where that could go in terms of the impact on the freedom of citizens of the United States. And so the first time I was on with you, I knew that the Ripple case was important. But as I thought more about it, the ramifications are really quite profound. And, you got a lot of amicus support at the trial level. I would expect a tsunami of amicus briefs in support of Ripple and XRP if this goes to the second. It's that important.
Yeah, I certainly believe so too. James Murphy, thank you so much for being here with us today. And I hope you'll come back as soon as we get a ruling or any more information out here in this ever-changing landscape that is digital assets and crypto. Thank you, man.
Brad, I love being on with you. You do such a wonderful job keeping people informed and bringing enthusiasm and a sense of humor to it. You really have a fantastic show, and success.
Hey, thank you so much, James. Don't go anywhere. I'm going to wrap this up for the crowd.